I watched my brother's face go completely still the moment the attorney said my name. Not surprised, not angry, just still. Like every lie he'd ever told had finally run out of room to breathe. 3 months earlier, I would have done anything to avoid being in that room. I would have signed whatever he put in front of me, nodded at whatever the family lawyer said, and driven home to my apartment in Raleigh telling myself it was fine, that I didn't need any of it, that I was better off. That's what 6 years of being called the difficult one does to you. It makes you believe it. My name is June. I'm 34 years old. I'm a commercial real estate analyst, and until 14 months ago, I genuinely thought my brother Mitchell was the only person in our family who actually loved me. I was wrong about that too. Our father passed away in October of last year. Pancreatic cancer, which moved fast the way it always does. 6 weeks from diagnosis to the end. I flew back to Charlotte the day we got the call and stayed through the funeral, sleeping in my old bedroom, eating casseroles that neighbors dropped off, trying to hold my mother's hand without her pulling away. She pulled away. She had always pulled away from me, even when I was small. I used to think it was something I'd done, some personality trait I'd been born with that made me harder to love. When I was 12, I overheard her tell my aunt that Mitchell was the one who was like her. Easy, social, effortless. I didn't ask what that made me. My father was different. He was quiet and a little awkward, and he liked crossword puzzles and bird feeders, and he never once made me feel like I was too much. We used to sit on the back porch on Sunday mornings before anyone else was awake, him with his coffee and me with a glass of orange juice, not always talking, just being there together. I thought Mitchell felt the same way about him. The will was scheduled to be read 3 weeks after the funeral at the offices of Harding & Cole on Tryon Street. I drove up from Raleigh the night before and stayed at a Hampton Inn because my mother had made it clear, without quite saying it, that I shouldn't plan on staying at the house. Mitchell texted me the night before. "See you tomorrow. It's going to be fine." I remember reading that and feeling something settle in my chest, like I could exhale. Mitchell knew what was in the will. He'd been in Charlotte the whole time, helping our mother with the practical things, coordinating with the attorney. He'd told me on the phone that Dad had been fair. I took that to mean equal shares. The house, the investment accounts, the small commercial property our father had owned on the east side of Charlotte for 30 years. I should have asked him to be more specific. The conference room at Harding & Cole was the kind of room designed to make you feel like decisions had already been made. Dark wood paneling, heavy chairs, a credenza with a silver coffee service that no one touched. I sat on one side of the table with a paralegal I'd never met, and Mitchell sat across from me next to our mother and their family attorney, a man named Mr. Sutton, who had apparently been the family's lawyer since before I was born, sat at the head of the table with a leather foldor in front of him. I noticed that Mitchell had brought a notepad. He uncapped a pen and set it parallel to the edge of the table, very precise, and I remember thinking that was strange. "Who takes notes at a will reading, mister?" Sutton read through the preliminary language, the executor designations, the small specific bequests, my father's watch to Mitchell, his bird books to me, a savings bond to a cousin, and then he got to the assets. The house went to my mother outright. That made sense. The brokerage accounts were split between Mitchell and my mother 70-30. That was the first thing that felt off, but I told myself I'd misheard. Then Mr. Sutton got to the commercial property. It was a mixed-use building on Albemarle Road. 3 retail units on the ground floor, 4 apartments above. My father had bought it in 1991 for $180,000. According to the appraisal summary Mr. Sutton slid across the table, it was currently valued at just over $1.4 million. It went to Mitchell entirely. There was nothing for me. Not a percentage. Not a buyout clause. Not even an acknowledgement that I existed in the paragraph about that asset. Mr. Sutton read the language twice, and I sat there, and I counted the wood panels on the wall behind his head, because if I looked at my brother's face, I was going to come apart. My mother reached over and touched Mitchell's arm. A small, private gesture, like they were sharing something they'd already agreed on. I understood then that the text the night before hadn't been reassurance, it had been management. I asked Mr. Sutton very quietly if there was an error. He said there was not. I asked if there was a separate document, a codicil, something that addressed the property division differently. He said there was not. I asked if my father had left any letter of instruction, any written explanation of his intentions. Mr. Sutton glanced at Mitchell before he answered. Just for a half second, but I saw it. He said there was nothing further. Mitchell waited until we were in the hallway to speak to me. My mother had stayed behind to sign some paperwork, and it was just the two of us standing near the elevator bank, and he said, "June, I know this is hard, but you have your career. You've been doing so well on your own." Mom and I felt like, "You and Mom decided this together," I said. He didn't deny it. He just said, "Dad trusted me to handle the estate in a way that made sense for the family." I walked to my car and I sat in the parking garage for a long time without starting the engine. The property on Albemarle Road generated approximately $8,400 a month in rental income. Mitchell didn't know I knew that. He didn't know I'd looked it up. He'd always assumed I was the impractical one, the one who lived in her feelings, the one who needed to be managed rather than consulted. It was the first time I realized that assumption had been protecting me. I drove back to Raleigh and I did not call anyone. I made a pot of coffee and I sat at my kitchen table and I opened my laptop and I started reading. I should tell you something about my job. I analyze commercial real estate for an investment firm. I spend my days looking at cap rates and lease structures and zoning classifications, and I am, without any false modesty, very good at it. My father knew this. We used to talk about his property sometimes. He'd ask me questions about the rental market, about whether he should refinance, about what improvements might increase the NOI. He called me his secret consultant. My mother always changed the subject when we got into it. It took me 4 days of digging before I found the thing that changed everything. My father had refinanced the Albemarle Road property 8 years ago. The loan documents were public record, filed with Mecklenburg County. The refinance had pulled out a significant amount of equity, $340,000. I'd known about the refinance in a general way, but I'd never seen the details. When I pulled the filing, I saw that the loan had been co-signed. By me, not by Mitchell, not by my mother, by me. My signature notarized on a loan document from 8 years ago that I had absolutely no memory of signing. I stared at the screen for a long time. Then I called a real estate attorney named Ms. Okafor, someone I'd worked with professionally on a transaction in Durham, and I described what I was looking at. She was quiet for a moment and then she said, "Send me the document." She called me back 2 hours later. Her voice was careful. "June," she said, "I need to ask you some questions about your relationship with your father and his estate planning." What followed was 6 weeks of the most meticulous, uncomfortable, clarifying work of my life. Okafor pulled every recorded document associated with the Albemarle Road property going back 30 years. The original deed, 3 refinances, a partial transfer of interest recorded 11 years ago that had been quietly reversed 2 years later, and buried in the amendment to that reversal, a single paragraph that Mr. Sutton had apparently not mentioned to anyone in that conference room. My father had granted me a 50% tenancy, in common interest in the property in the original transfer document, and when the reversal was filed, a legal error in the drafting had left that interest intact. My name was still on the title, had been for 9 years. The property had not been Mitchell's to inherit because half of it had never belonged to my father to give. Mitchell owned half a building, I owned the other half, and he had no idea. Miss Okafor filed the necessary notices, and we requested a formal partition proceeding before the Mecklenburg County Superior Court. I did not tell Mitchell. I did not tell my mother. I did not call Mr. Sutton, whose failure to catch this error I intended to address separately. I drove back to Charlotte on a Tuesday morning in March, and I sat in a wood-paneled courtroom that felt nothing like the wood-paneled conference room where this had all started, and I waited. Mitchell arrived with his attorney, a man named Mr. Greer, who wore a very good suit and looked like he handled mostly business disputes for people who expected to win. Mitchell saw me from across the courtroom, and his expression went through about 4 different things in 3 seconds. Surprise, confusion, something that might have been guilt, and then, settling over all of it like a lid coming down, a kind of studied calm. He thought this was still manageable. The judge was a woman named Judge Tatum. She had reading glasses on a beaded chain, and she did not appear to be interested in anyone's feelings, which I respected enormously. Miss Greer opened by arguing that the recorded interest was a clerical error, that my father's clear testamentary intent was to leave the property to Mitchell entirely, and that the court should look to the will as the controlling document. He used the phrase family harmony twice. I watched Judge Tatum's face while he talked and nothing moved. Ms. Okafor stood up and walked the court through the chain of title, document by document, date by date. She explained that a tenancy in common interest cannot be divested by a will, that you cannot give away what you do not own. She placed the recorded documents in the record one at a time, calm and precise, and when she was finished she sat down and folded her hands. Judge Tatum looked at Mitchell's attorney. Is there a recorded instrument conveying Miss Hartley's interest out of her name? Mr. Greer said there was not. Is there a deed of gift, a quitclaim, any document signed by Miss Hartley relinquishing her interest? There was not. Then I don't see the ambiguity, counselor. Mitchell leaned over to say something to his attorney and I watched him and I want to be honest about this, I felt something complicated. Not triumph exactly, not satisfaction. Something more like grief with a hard edge to it. Because this was my brother, this was the person I used to build blanket forts with on rainy Saturday afternoons. The person who called me when his first serious girlfriend broke up with him and cried on the phone for an hour. I had loved him genuinely, and he had sat across a conference room table from me and watched me walk out with nothing, and he had sent me a text the night before that said it's going to be fine, and he had known exactly what was in that will. He had known for months. He had been involved in the drafting. Mr. Sutton had looked at him before answering my question about additional documents because he'd been taking instructions from Mitchell, not from my father's actual intentions. The Sunday morning porch sessions, the questions about cap rates, the nickname, Dad had trusted me. But the people who handled the paperwork had trusted Mitchell. Judge Tatum issued a ruling from the bench. The recorded title interest stood. I was a 50% owner of the property. Mitchell's options were to buy me out at fair market value for my share, or to agree to a court-managed partition sale. He chose the buyout. His attorney called Ms. Okafor that afternoon. I want to tell you about the moment I walked out of the courthouse. It was a Tuesday in late March, and the sky over Charlotte was doing something beautiful. That particular blue that happens after rain when everything is washed clean, and the light hasn't quite decided what to do yet. I stood on the courthouse steps and I called my friend Deb, who is the only person I'd told any of this to. And when she answered, I didn't say anything for a second. She said, "June, are you okay?" And I said, "Yeah, I think I actually am." The buyout was completed 6 weeks later. Based on the appraisal, my 50% interest was valued at $710,000. Mitchell wired the funds to a title company escrow account on a Thursday morning, and I sat in Ms. Okafor's office in Durham watching the confirmation come through on her screen. I didn't go back to the family house. I didn't call my mother. I sent Mitchell one text. I hope you understand now that Dad knew exactly what he was doing. He didn't respond. Maybe someday he will. Maybe he'll figure out that our father had loved both of us, had trusted both of us, had put my name on that title on purpose, I believe, even if he hadn't updated the will to match. Or maybe he never will. That's not something I control. What I did with the money is not dramatic. I didn't buy something flashy. I put a substantial portion into a small commercial property of my own, a retail strip in Cary that I'd had my eye on for 2 years and hadn't been able to afford. My father would have liked to hear about the lease terms. He would have asked me all the right questions and nodded and eventually said something like, "You know what you're doing, Junie. You always did." I think about him on Sunday mornings sometimes. The coffee, the bird feeders, the comfortable quiet between two people who understood each other. He left me something after all. He just made me find it myself.